Today, we're digging into a classic neighborhood showdown, a homeowner, her HOA, and a legal battle that, believe it or not, hinged on the meaning of just two little words. This is a great story about what happens when the strict letter of the law smacks right into a real-world, everyday living situation. So let's just jump right in with a question that, hits close to home for so many people. You own your home, right? But maybe you need a roommate to help pay the mortgage. Can your HOA, the Homeowners Association, actually step in and tell you, nope, you can't do that? Well, believe it or not, that is exactly what happened to a woman named Kim Grill in Sedona, Arizona. Her HOA literally took her to court to try and force her 73-year-old roommate out. And that kicked off this whole legal fight that was really about what does it even mean to share a home? Okay, so let's set the stage for this neighborhood legal battle. On one side, you've got a homeowner who's just trying to make ends meet in her dream house. And on the other side, you've got the HOA trying to enforce the very rules that everyone, including her, agreed to follow. So here are the basics. The homeowner is Kim Grill. She buys this big, beautiful 5-bedroom home in Sedona. But, to make the finances work, she gets a roommate, a guy named Ken Snyder. Pretty normal stuff, right? Well, not long after, she gets a notice from her HOA. They're not just accusing her of breaking the rules, they're taking her to court over it. And what's really fascinating here is that this entire, probably very expensive legal fight, it all boils down to the specific wording in the HOA's own rulebook. Their covenants, conditions, and restrictions, the CC&Rs. Okay, so the HOA's entire case hung on this one sentence. Their argument was that if the owner is living there with a roommate, that's a lease of less than the entire unit. And on the surface, that sounds pretty straightforward, right? Case closed? Well, not so fast. And this is where it gets really interesting. The very same rulebook had another clause. It said that homes had to be used by a single family. And then it defined single family as up to 3 unrelated people, as long as they maintain a common household. And that right there, that phrase, is the legal loophole this whole case is about to slip through. So that leads to the million-dollar question, right? What exactly is a common household? Does that mean you share groceries, watch the same shows, split the bills? The HOA's rulebook never said. They just left it completely undefined. And that one little oversight, that ambiguity, became the absolute heart of this entire legal battle. All right, so let's look at the HOA side of this. How did they build their case? You got to understand, for them, this wasn't really about the roommate himself. It was about making sure the rules were followed, period. To the letter. So the association's argument was, look, our rule against leasing part of the unit is crystal clear. But they had another card up their sleeve. They pointed to a disclosure statement that Kim Grill signed before she even bought the place, a document that said, pretty explicitly, an owner may not occupy a home at the same time as renting out the home. So for them, allowing this would set a really bad precedent, and they argued, disrupt the whole vibe of the community. And this quote from one of the HOA directors really just sums up their entire position. She was asked, what actual damage is this roommate causing? Is he loud, messy? And the answer was, well, nothing really. The damage to the community, she said, was in the failure to comply with the letter of the law. It was all about the principle. A rule's a rule. Okay, so that's the HOA's take. Now let's flip the coin and look at the homeowner's defense. Her team wasn't arguing to just throw the rules out the window. Instead, they were arguing for interpreting them with a little common sense, in a way that actually benefits the community. Her defense was actually pretty simple and, very logical. First, she and Ken Snyder are a common household, which, remember, the rules allow. Her roommate agreement even says he has access to all the living spaces. But here's the kicker. Her best argument was a practical one. She basically asked, what's better for the neighborhood? Me, the owner, living here with one quiet long-term roommate, or me moving out and having a revolving door of new unsupervised renters every 30 days? Because, ironically, that was allowed by the rules. So, when you strip it all away, it really just boils down to this. The HOA looks at the situation and sees owner plus renter, which equals a violation. But the homeowner looks at the exact same situation and sees 2 people sharing a house, a common household, arguing that having the owner there is actually a good thing, not a problem. Both sides made pretty compelling arguments, all based on the very same document. It's a perfect storm of contractual ambiguity. So with all that, how did the judge actually decide this thing? who wins? Well, the judge, Tammy Eigenheer, was super methodical about it. She basically went down a checklist. 1. Is the lease long-term, over 30 days? Yep. 2. Does the agreement say the roommate has access to the whole place? Yes, it does. Which brought her to the final deciding factor. Do these two people maintain a common household? And right here, this is the aha moment. This is where the HOA's entire case just crumbled. The judge pointed out what seems kind of obvious in hindsight. The HOA never bothered to define common household in their own rules, so it was left wide open to different and perfectly reasonable interpretations. So the verdict came down, petition denied. The homeowner wins. The judge basically said, look, two people living together, sharing expenses, with full access to the house, that could reasonably be interpreted as a common household. And since the HOA couldn't prove that it wasn't a common household, they lost. Kim and her roommate got to stay. So, okay, why are we talking about this? What's the big takeaway from one neighborhood dispute in Arizona? Well, it's because this case is actually a powerful lesson about vague words, and it applies to pretty much any contract you'll ever sign. Here's the key lesson. Anytime you have poorly defined words in a contract, you create gray areas. And when a rule is vague, a judge will often favor a reasonable, real-world interpretation over a super strict one that just doesn't make sense. In this case, the HOA's failure to define just two little words, common household, cost them their entire case. And his whole story leaves us with a really important question to chew on. HOAs exist to protect the community, right? To keep up standards and property values. But a case like this really highlights the tightrope they have to walk. So when do these community rules stop protecting everyone and start overreaching, infringing on a person's right to just live in their own home? It's a tough balance, and it's a question that communities all over are dealing with right now.